that was Jennifer saying that you were going to ask your question. Pop it up there and we will.
If I create my own drawing that looks similar to, but is not an exact copy of a drawing that I licensed from one of the major online sources, such as Adobe Stock, do I need to worry about copyright infringement, or can I use it in my book publishing? So she bought it from Adobe Stock, right? Or licensed from Adobe Stock.
The issue is that the extent of the extent of what license you're getting from Adobe. I think probably the best way to do your due diligence there is to read the actual license you get, because the license might just be to copy and reproduce that exact image, and it might even expressly disclaim any license to create like a derivative work or something like that, in which case I would be worried about copyright infringement if you're explicitly making something similar and there's a very clear connection to the previous one. Short answer, read the license and if it says you're allowed to do that, then you're in the clear. And if it doesn't, then I would.
It's okay.
Yeah.
You mentioned the word derivative, and I'm wondering what definition. And does it?
Everything's on table. Do we have the camera?
Yeah, short answer, yes. I think I don't think derivative is defined in the Copyright Act per se. It's going to be a judge-made, context-based definition. A lot of the time it has to do with, when we're talking about derivatives, we're talking about a wide range of things. It could be like what was being said here, an image that is based on another image that takes a lot of elements and looks similar. And it could be like a cartoon character from a TV show being reproduced on a t-shirt. And that's also a derivative. It depends on a lot of things, but one of the rights you get when you have a copyright is the right to make derivative works of the original copyright. And so anyone making a derivative is not going to be able to do that. Or anyone trying to make a derivative of your copyright can't do that.
And I don't mean to take up too much space here.
Keep going.
Yeah.
We're just talking.
How would that be determined? In other words, you mentioned this, but
what is a derivative and what isn't a derivative? It is a little ambiguous at the end of the
Richard,
day.
we got it.
It's working.
Oh, it's working?
It's working.
Oh, okay.
We are good.
Okay.
And are you talking just about US rights, or is this cross border as well?
I am talking just about US rights, really. I'd say we're not experts on all the various international copyright laws. Probably the grand majority of them have a similar right that I'm talking about here. But like I was saying, whether something is a derivative of one thing is ambiguous just by its own nature, just by virtue of art being ambiguous in that kind of sense. Yeah.
Just one more follow-up. In terms of YouTube, as I understand, part of this, the CD is involving YouTube creation. So the creation for YouTube. How does the notion of derivative fit into that world? Does it affect it, for example? Does the YouTube license specifically address derivatives? I would assume that's the dominant license in this case, or the applicable license.
So the question is, does the YouTube license affect derivatives?
I don't. So when you say like derivatives, are you talking about someone making a YouTube video and kind of it being derivative of something else or another YouTube video? I don't know exactly, what the terms of use, right? The license inside that on youtube.com are, like off the top of my head.
Most social media platforms, though, do allow for sharing of content within the platform. So if you're using a derivative work on YouTube, then there's a pretty high likelihood that would be okay as long as it stays on YouTube. If you take the content and you move it to a website or another platform, then you stand a higher likelihood of getting into trouble.
If you yourself do.
Well, if anybody does it, if you're taking a third party's video,
right,
and then editing it and incorporating it into your video, you can do that if you're staying on YouTube. If you're taking it and moving it someplace else off the platform, then because when the user agreements are such that you surrender your copyrights on the platform.
Yeah. The other thing I'll say is that a lot of these platforms have easy ways for copyright owners to submit claims against videos on the platforms. And so that's always a concern because it tends to be easier for a copyright owner to claim a takedown on something like YouTube than it would be for the video owner to contest the takedown and get the video back up.
Okay, so we have another message from the chat from Elaine Martin. I'm starting my entertainment law firm for content creators. Where can I get templates and clients? I know there are some events in Miami, but in addition to that, where else can I get clients? I live in West Palm Beach. Not sure if you can provide guidance on this. I can just say one thing quickly from my marketing research, that in Miami, there is a lot of entrepreneurial activity. I think Miami is a good hunting ground for you. Do you guys have any response to that?
So the question is for an attorney seeking to find clients in the YouTube space, entertainment law.
For content creators, templates and clients, just starting out.
You need to have a website. You need to market yourself on social media and on YouTube. You need to promote your website using pay-per-click and SEO. And you have to go where content creators are and become known to that community. So those are the
Right.
things that I would suggest as a starting point.
Maybe a podcast.
So that is one thing. We do go to podcast conference and we do have this podcast meetup, and the law firm is getting referrals and clients from this. So you could do something. I think one thing that Richard did when he started Gearhart Law as an intellectual property law firm almost 20 years ago, he used technology tools that other law firms weren't using yet. So he decided to put up a website in 2006, and he had people saying, that's dumb.
But I was too dumb to listen to them. I turned out to be lucky.
So if you can jump ahead on the tech, you might, I think that's really a huge help.
But you want to place yourself in a position to establish relationships with potential clients. So that's what it's all about, right? If you're an attorney or in any other service business, is establishing a relationship. So think of the people that you would like to attract to clients and then come up with a strategy for meeting them. And that is probably the quickest route.
As Sonia said, a podcast is a great way because you could interview them on your podcast.
Maybe we should start this.
Okay, I want to go through the last few comments.
Oh.
Okay. Oh, I lost my mic again. I think my computer. Okay, I'm going to talk loud into my computer. I hope you all can hear me. I have a website and blog. I'm also planning on creating YouTube videos. Do I need to worry about copyrighting my material on my blog, or is that implied? Any suggestions on how to protect video content on my website and or YouTube? Can you talk
I
really?
think, do I talk loud?
Yeah,
It's like,
we lost the
it's like it's
roadcaster
coming
again.
up there though.
What?
Can you guys hear us? You just pop a.
Stephen can.
I say can hear. Okay.
Really?
Okay.
Okay, thank you.
I'll try and enunciate. I think there are a few parts to the question, but the basic answer is that whenever you fix your creative work in a tangent, whether that be in the form of a video on your website, or if you just write it down on paper, you get some level of copyright protection. You have a copyright at that point, but you're not really able to enforce copyright rights at all until you register it with the federal government. To the extent that you're worried about enforcing your copyright potential infringers, then you have registered before any of that happens. In theory, you could do it after, but then you also some other statutory rights to damages and that kind of thing. I'd say if you're just starting out, I wouldn't worry about like getting a federal registration on every little thing you do. But if you have videos that are creative works that are dear to you and that are probably a tentpole of your business, then I would definitely consider getting a registration on at least the most important ones.
Okay. Oh. do you-
And I was just going to say, insofar, well, wait a minute, this could be important. No. So insofar as blogs go, the Copyright Act was amended a couple of years ago to allow creators to register a whole string of blogs. So you can get all the blogs in one copyright application. Is that something that we should know about?
We're just talking about the next question. Keep going.
So I'm done.
Oh, okay. Do you want to ask the next question from?
Oh, yeah, sure. So the next question was, what about showing a podcast on YouTube for a group on Zoom?
What about it?
So can you take somebody else's YouTube podcast and show it to a group
Oh.
like this? Could I play somebody else's YouTube?
Could you do it? Yes. Is it technically copyright infringement? Probably.
But you want to talk about fair use, right?
I think there's a lot to consider. The reason why you're doing it in the first place and the nature of the video, to the extent that you're doing it to educate people or critique the video in the first place, you have a good argument for fair use, which is fair use is just the basic copyright defense that you can use someone else's copyright for the purposes of journalism, critique, education, commentary, those kinds of things. So if that's what you're doing, then I think fair use is a good argument there. If what you're doing is if you're just streaming a movie on Zoom for other people to watch and collecting ad revenue on it or something, that's closer to copyright infringement and you're not really fairly using the copyright.
Right. If it's for a commercial purpose, then you're pretty much done. And the whole fair use defense is usually, all of these copyright concepts are pretty squishy. There's no bright lines. They're very fact dependent. And so we always tell our clients, err on the side of caution. Make sure, try to get permission where you can if you're going to do anything, if you're going to use a photograph. We have clients that receive cease and desist letters because they copied something from Google Images and put it in a blog post, and they got a cease and desist letter from a law firm representing the photographer, and they want $20,000 for that single use. Now, they would probably never get it, but you have to hire a lawyer or negotiate, and you'll probably end up paying something. So the point is that just be careful when you're using other people's works, because if you get caught, it can cost you money. And they have all sorts of AI bots out there that are crawling all over the internet, just looking for copyright infringements. And it's an industry and it keeps growing. Be very careful.
Yeah,
Yeah.
I was going to say I had that inadvertently happen to me as well. It wasn't on YouTube, but I had a picture that an assistant pulled for a blog and put that up, and I got one of those.
One of those stinky letters.
Those letters, it was even more money, and I was like, "What? I can't pay that much." And so I just took it down and waited to see if a second letter would come, which didn't. So I got really lucky, but I learned that lesson.
I think that's another
Hard.
point. Yeah, I think that's another point too, is if you get a nasty letter, don't freak out and just do what they say or give them a bunch of money or take all your stuff down or whatever. You should talk to an attorney. I think
I think I would take it down ASAP, period, just so that you're not putting up something that's not yours. So I would get it down off of everything, but then talk to an attorney.
I think it might still be
because
a good idea
it's
to
still
talk
a
to
good
an attorney,
idea,
you
so that
know?
you have some protection or backup, or you have a case.
Yeah, I
Yeah,
think it's a good idea
always.
to talk to an attorney at the very least if you get a letter like that, especially from an attorney. A lot of the times these letters are, like Richard said, they're law firms built on the business of scrolling the internet for websites and images that are using these, like from a big photo database like Reuters or iStock or something. And so they send out tons of these letters, and some of them may have a lot less merit than some others, I'd say. So definitely talk to an attorney, because you may be fairly using the image, or the image might not have a copyright registration and they're just sending out these letters. And so it's always a good idea to talk to someone, because the context will really change really what the right course of action is and whether you're actually going to wind up having to pay out anything.
At circumstances where the letter comes and it's the wrong copyright registration, and then you dig a little bit further and there is no copyright registration. So now you have a defense and you have some leverage against the other side. So it does make sense to talk with somebody knowledgeable, even for a few minutes.
And that,
just to get an opinion.
sorry, that's one thing we're going to hit on a little later. I wanted to go through these questions first because everybody's got super great questions on here. So there's a couple. Doesn't YouTube offer copyright upon upload? And would you have to register each video on YouTube to protect your content?
I don't, do you know?
I have never, copyright arises automatically with the creation of the work. So you automatically get a copyright if you create something. If you want to perfect the copyright, you register it. So simply creating the video, you have a copyright. I'm not sure that putting it, did you say on YouTube or Yahoo?
Yeah, YouTube.
Yeah, YouTube, that doesn't, I don't think that changes the status of the
Right.
copyright.
It would be publishing whatever the work is, but you definitely don't have a federal registration if you put the video on YouTube, and YouTube doesn't have any kind of authority to do that.
So why would you need a federal registered copyright? If you automatically have a copyright on any artistic thing you create, why do you need to register it?
You don't. You don't necessarily always need to register everything. The question is, do you want to enforce it? Do you want to have the option for damages down the road? Are you a commercial content creator that really relies on creativity for a living? And you're going to take it a lot more seriously if you're an amateur photographer who has a website. You don't necessarily need to do that. You can register your own copyrights. You can go to the Library of Congress. I don't know.
The copyright.gov, it's $60 to $5. Depends on what it is exactly.
Yeah, it's a 2-page form. If we do it, we charge more because we have to open a file, and for some cases, if it's important, it may be better to get an attorney involved, but there's a lot of copyright. You can file your own copyrights. And sometimes people get a little bit confused on the forms, and that's where having a professional can help. But you can learn how to do it, and then it's just the time it takes and the $60.
So there's another question here that I think it's about true crime podcasts, but I think it's pertinent to a lot of different types of podcasts. So what would you have to keep in mind if you wanted to start one to avoid legal repercussions? And are there certain permits that you would need to get? Because I think people are doing podcasts about music, they're doing podcasts about movies. Now this is true crime. So where do the lines blur? Like, how much can you use? What can you do with that?
So I think there's a lot that goes into it. As far as, like I was saying earlier, if you're doing a podcast if you're talking about movies or about music or songs, if you're commenting on those things, if you're critiquing them, or if you're doing some kind of news journalism, those things can fall under fair use. And so at some level, you can use clips from songs or clips from movies to demonstrate your points when you're doing those things. The question is, how much of that are you doing, and how much of it are you just reproducing the work for some commercial benefit? And fair use is always going to be an ambiguous balancing test, but I think, like I was saying, if at the end of the day, the goal is to critique, comment, or provide news, then you're probably going to fall under fair use.
And then there's also the situation of if you're ripping off a rich celebrity, it doesn't matter because they've got so much money, they're going to come after you. I remember one case where it was Oprah Winfrey, and some ladies started the Oprah Winfrey fan club podcast, and Oprah went after them with lawsuits and complaints, and she completely shut it down, even though it was a very supportive type of podcast. So the celebrities especially will go out of their way to protect a brand. And unfortunately, I think the podcasters thought they were doing something really good, but they ended up getting whacked in the end. Let that be your lesson for today.
Yes. So,
That's
do
interesting.
you want to ask about Joe the Fisherman?
Yeah, sure. That's interesting, actually, because there's a soap opera. I've been on soap operas, and there's a soap opera, but I don't think they have any trademark or copyright anything. They just talk about all of it. Anyway,
Yeah.
So Joe the
interesting. Okay. I'm very interested in protecting the company name and/or protecting the name a video is done under. Joe the Fisherman would be the name of the channel, and the production company would be like Fisherman Productions. I know I can copyright and trademark a logo, but how do you do it with just a name?
It's pretty much the same process. So a trademark is any designation of source. It can be a name like Coca-Cola, just the words are a trademark, or it can be the logo like the distinctive Coke font and with the red background, whatever. It's more or less the same process to get a federal trademark, whether it's a word or a logo. Obviously, there are different boxes to check on the form online, but for the most part, we do that. We do that a lot. We trademark names or logos of companies. You can do just the name, you could do the logo, you could do the logo and the name. It really comes down to case by case, but yeah.
Yeah, no, sounds
Could
good.
you actually, I mean, I
agree
know
with
we were going
everything
to
you
talk
just
about
said.
trademark, and I think that is one of the things that people are interested in. Can you just walk us through the process on it? And there's all there's the different M's and I know when we finally
like
got the TM, I was like, yeah,
the notices. Yeah.
You could put on it and when.
So for the most part, there's two kind of notice symbols that you're going to be using for trademarks. It's the little TM that you put up there, the R in the circle. TM obviously just stands for trademark. You can more or less put that on something without it being registered or even applying for it, because again, similar to copyrights, once you use a name of something or a logo to signify the source of whatever good it is that's connected to, that's a trademark, and you're accruing to some level, you're accruing common law trademark rights. So you can, especially if you mark it as a trademark with the TM, then it puts everyone on notice that's what you're using as your name or your logo as a source identifier. So the TM you can put on your name right off the bat. The R is reserved for things that have been federally registered, and not just applied for, but actually granted registration. To get that, you're probably going to want to speak to an attorney. You can do it yourself, just like with the copyright. You can go online to the USPTO website and file for your own trademark. But plenty of times we have seen people come in who have done that, and they wind up with an issue because even more than the copyright process, the trademark registration process is very technical. And especially lately, the trademark office has been getting very particular about people following the instructions and their manual and doing everything the right way to actually get a registration.
And Sonia, you have a trademark and
Yeah.
you got scammers coming after you.
I did. So I was very happy. I did look online first, but I will say going through a lawyer was a much more complex process and much more detailed, and I felt way more covered. So I highly recommend getting a lawyer
So
for that.
was for Motosize?
For Motosize. So
Yeah,
I have
okay.
Motosize, my brand, trademarked. But then I also got a scam notice saying that I owed like another $2,000 and my registration was up and that like I needed to pay the money by, of course, a date in the very, very near future. And I, again, was like, what? I thought I just paid. And so I called the lawyer and they're like, no, that's just there's all these scam companies out there sending these kinds of letters. And that was when I was really happy that I had a lawyer to go and that they could tell me for sure, you're covered, you're fine, you're paid up, throw that away and throw away the next one if you get one, which I did actually.
Yeah.
So can I no, that's a great story. And we get those scams all the time, and they're scams. Unless you get the correspondence from your lawyer, it's a scam. But people get worried because they're like, I don't want to lose my trademark.
It sounds really official. And it took about 2 years to get the full registered trademark. So yeah, you don't want to mess that up.
It takes a while. And just getting it examined in the first place, now the wait time is like 8 to 10 months. Then after that, there's a whole process. And depending on if you're using the trademark first or not, it can be 3 years before you get a registration after you apply for it.
There was a guy in Pennsylvania who used the term the trademark office and created these very official looking documents, and they caught him, they sent him to jail. He like has to repay $2 million. Wow. So it's this guy, but so a lot of people fell for it.
Yeah.
A lot of these originate in Eastern Europe. So you've got to keep your eyes out. But maybe we should put up the slide where we go over the different types of intellectual property.
Absolutely.
And then maybe we could just like introduce ourselves. So I don't think we've done that yet.
Yeah.
Because we got.
What's that?
Oh yeah, we'll be up there.
I think I can screen share that. Let me see. Let me get this. There we go.
Do you guys want to start by introducing yourself? Screen share.
Stephen?
Okay, sure.
I know you usually start with us, but I think
yeah.
we should start
No, I
with you
didn't
guys.
realize.
Let's go.
I'm Stephen Friedman. I am an attorney here at Gearhart Law.
He's an ace, an ace.
I'm an ace, apparently. That's good news.
So here he goes.
Yeah, no, I specialize, as I guess you could tell, in trademarks and copyrights. And yeah, we do a lot of work, especially with entrepreneurs, getting their businesses up and running. And on the IP side of things, we do trademarks and copyrights registration in those offices. We do contractual stuff, business formation, all kinds of stuff. Yeah.
Right. Yeah. My name is Richard Gearhart. I'm the founder of Gearhart Law. My wife, Elizabeth, is running this meetup. And so I'd like to say thank you for inviting me to this special event. I used to work at Novartis. You headed up the intellectual property function there for a while. And then I left and Elizabeth said, you should go out and start your own practice. And I was like, I think it was mostly because she didn't want to move again because we moved from Georgia to New Jersey, which we love, by the way. We've been here 20 years now. And she didn't want to end up in another place. So she said, start your own practice. And I'm like, oh, okay, that sounds like a good idea. 20 years later, we are, and we've got over 5,000 clients. We've got about 25 team members. We've done thousands of trademarks and patents and just intellectual property. It's been great. And we've met so many amazing people during this process. I really like interacting with entrepreneurs because they have so much passion and they're so excited. There's other types of law, matrimonial, wills and trusts, where it's just so sad. But intellectual property is just like the best because people are really excited and you get to share in their successes and participate in that. So yeah, we're super lucky.
Cool. Why don't you go? Okay. My name is Sonia Satra, and I am joining in with Elizabeth. It's her podcast meetup, but I'll be coming in and co-hosting for a while, and I'm thrilled to be here. I have a company. I'm a coach, and I do something called Modicize, which is trademarked, and it's a hybrid of movement and exercise and mindset. And in my other life, I was also an actress. I still do it sometimes, but I was on soap operas. I played Lucy Cooper Spalding on Guiding Light and Psycho Nurse Barbara on One Life to Live.
To believe that you were a psycho nurse.
Psycho. But happy to be here today, and I think it's a really important topic as business owner, small business owner, and getting your trademarks and getting your copyrights and really understanding all of this. So happy to be here with you guys.
Thank you.
And I'm Elizabeth Gearhart. I started this meetup with Stacy Sherman, who decided to take a break because she had to make some money. We're doing all this for free. That whole thing, you have to. Yeah, I know. But she was lovely. So Sonia stepped in while Stacy's taking a break. And yeah, I told Richard I would do anything he needed me to do to help him start his law firm. And that was one of the biggest mistakes. No, I'm just kidding.
I took full advantage of that.
So
for the record.
I started writing helped him write the first website, and then I got my patent agent's license, drafted patent applications for a while. Then we needed somebody that knew about intellectual property to lead the marketing because it's so intricate and it's just so easy to get things confused. So I took over the marketing effort, and I've been doing that ever since with Richard. And we started our radio show, Passage to Profit, in New York, 7 years ago. And it was a podcast too. And then during COVID, we did it from upstairs in the law firm here where we are. And Richard bought all this really great, cool equipment. He brought the Rodecaster, he bought these $400 microphones, he bought these big lights and everything. Then after COVID, we started going back into the city to record the podcast. So I said, why don't we rent the studio out? So we've spent the last year fixing it up for public consumption. And tonight, the people here are getting a sneak. A month from now, on April 28th, it's a Monday night, we're going to have the grand opening. But tonight, they get a little view behind. So that's me. We did have something really fun happen. So we have an attorney named David Postolsky. He's a Gearhart Law partner who's very active in the intellectual property law section of the American Bar Association. And he put together this book. He got everybody to write a chapter on marketing.
how attorneys can help their clients market. And there's a chapter about podcasting. And guess who wrote it? So Richard and I wrote it, yeah. And Kenya, who used to be at iHeart, did the radio part. But now let's get to what Richard wants to really talk about. And that would be copyrights, trademarks, patents, and trade secrets.
So I don't know if I can discuss this because the words are in the wrong order. So it's
I know.
usually patents, trademarks, and copyrights, but you've got, what do you have? Copyrights, trademarks, patents, and trade secrets.
Amateur hour.
Dixon it out. I did it on purpose because this was supposed to be about trademarks and copyrights, and it seemed like the feedback I was getting when I was posting on LinkedIn and sending out emails and everything was people really wanted to hear about the copyrights. That's why it's first.
Oh, that, I can see that. Playing to your audience, is that what's
Yeah, I
going
was
on?
trying to play to the audience.
So I would say, though, I just want to talk really briefly about it because a lot of people don't understand the difference, and that is we know that because when I talk to them, sometimes we have to explain the difference. So I just want to make sure everybody's clear. So copyrights protect works of expression, video, music, written work, movies, stage plays. You can even protect sculpture,
Dances.
dances, architecture.
Yeah.
So all of that is protectable with copyright. So it's artistic works that have an artistic element, that have a creative element. Trademarks protect brands. So if you want to protect the name of your product or the name of your company, you would use a trademark. And trademarks, as Stephen was talking about earlier, arise out of use. So if you start using a name, then you begin to accrue trademark rights, and you can solidify those rights by filing a trademark registration with the US Patent and Trademark Office. And you go through a process in order to get it granted. And I think trademarks are really important, but I think what's even more important with trademarks is if you start a business, you want to make sure that you're not using the name that somebody else is using. So you want to do some level of searching to make sure that you're not out there working for several years, and then one day somebody miles away from you who has a federal trademark registration sends you a cease and desist letter. And this happens more often than we would like to admit. And so that creates a big problem because you either have to fight in court or you have to change your name. And so it's better to make sure that your name is clear or reasonably clear before you adopt it. So you want to do that at an early stage. And of course, you can protect the name of your podcast with a trademark, and you may want to do that. I've seen people say, my podcast used to be called this, somebody else had the name and they contacted me, and so I had to change it to this. So you want to make sure before you get out there and start putting a lot of effort into the marketing that you know you're free and clear. And then the other types of intellectual property are less relevant to our discussion here, but patents protect inventions and technology. And there's a whole universe of products and technology that patents will protect, everything from software to pharmaceuticals, to widgets, to consumer products. And we work in those areas as well. And then the last area is trade secrets, which is a secret that gives you a competitive advantage, and you have to keep it secret. But if you do that, then you can take certain legal actions if that trade secret is stolen by somebody. So those are the 4 types of intellectual property. And that's all I have to say about that, unless somebody has a question.
That was pretty thorough.
So
I've been doing this for 40 years.
Yeah.
If I don't know this, then I'm screwed, you know?
We did have some questions that we came up with before this meeting that we were going to jump into, but we've had such great questions. But the one question I did want to ask is, what if you are using your name and maybe you're just using it for a restaurant in New Jersey or something, and you didn't trademark it, and then somebody else decides a couple of years later they want that name and they trademark it? What happens to your business then?
A lot of things could happen. It really depends on the context here, because there's a million different ways it could go down depending on what the name is actually, what the other business's name is, how long you've been using it, how famous your mark is. Do they have a registration? When did they get their registration? Have they been using it longer than you, but just in a different geographic area? Have they expanded all over the country? So there's just too many questions that go into this kind of case, and trademark infringement and litigation can get really murky. But that's why, like what Richard was saying, getting a registration is really your best shield in this case. Yeah.
So even though it wouldn't be fair, they could make you quit doing business under your name.
Again, it depends. No.
Okay. But hopefully they wouldn't.
So can you repeat the question?
So you've had Gearhart Law, you didn't trademark it.
We did. We.
Well, I'm pretending. Okay. So let's pick something else.
If you hadn't, because it's your name,
Okay,
right?
okay. I'll pay closer attention.
So let's say you had not trademarked Gearhart Law, and somebody down the street sets up shop, and you've been here for 20 years and you didn't need a trademark, you didn't think. Somebody else sets up shop and they call their law firm Gearhart Law and they trademark it immediately. Then what happens to you?
They're scumbags. They're
And
how dare they? But seriously, in that case, the non-registered company has common law rights that extend to the geographic area where they've done business. And so you could file a cancellation proceeding against the company that filed the trademark, and you could have it canceled. And that would be one option if you wanted them out of the market. And you're entitled to carve out of the United States the area where you've been doing business, but then they would have trademark rights outside that area in the rest of the United States. So for a law firm, that's not so bad. If you have a product that you're selling, though, that's different.
So it could end up costing you more money anyways, hiring lawyers to do all that, than just searching for the trademark and registering it in the first place.
For sure.
Yeah, trademark is going to set you back maybe $2,500, which was the search and the filing fee and all the follow-up with the trademark office. That's pretty cheap insurance compared to what you're going to be paying. And the other thing, too, to keep in mind is that before we recommend a client file a trademark, we do a search. And if there's something similar, we tell them not to adopt that name. We suggest that they change it. So somebody if you file a trademark, it has the effect of deterring other people who want to use your name. And you never know about it because they're with the attorney across the street and they're doing that search. And your trademark is preventing them from getting a trademark. So even if you never go to court, having the $2,500 trademark is going to keep other people away from your brand. And so that's what the real advantage is. It's a registrations. It's like you go and you put your mortgage and you register your mortgage. And before you buy the property, they go through all the deeds and they make sure that you're the true owner, right? And it's that registering your property that keeps people from reselling the property or having issues. And it's the same kind of registration system with both patents and trademarks.
Oh, okay, I want to bring in something.
Am I monologuing here?
No, you're doing a good job.
Yeah,
but I'm so excited to bring this in from the chat. I've met Cindy Gel Armini, the paint diva, a few years ago. I think I interviewed her when I was doing something. And she has a book, The Paint Diva Method. It's copyrighted. She's going to do a TV show. Cindy, congratulations. That is so cool. And she thinks she should trademark the Paint Diva name. Can she just go through a government website and how much should it cost? So she sees websites out there that look like scams.
Yes, for sure. If you're going to go and do it yourself, make sure you're doing it on the USPTO website that ends in a .gov. You can do it yourself, but like I was saying earlier, there's a lot of complications and a lot of specific things you need to fill out on the trademark form that you're best off getting an expert to fill out that form for you. Because again, we've seen plenty of people come in who they filed their trademark by themselves, and after the trademark office gets around to examining it 10 months down the road, they had all these problems, and the trademark office issues an office action saying, here 15 problems you have to fix, and they say, I don't know how to do all of this. I need,
Sometimes it's not possible to fix it.
True.
You have to remember that trademark law is a body of law. It's not simply filling out a form and putting it in with the USPTO. There's a background of case law and legal principles that apply. And if you don't know those, you can seriously undermine your protection. So how important is it to do it, save some money? Maybe you don't care that much and it's worth taking a shot. People do, and they're successful. Or you can go to LegalZoom. If you want to save a few bucks, you can do that. But I think what a professional offers is a lot of experience, having filed hundreds, thousands of trademarks and seen them all through the trademark office and seeing the different fact patterns that arise when they're dealing with these issues, and understand what happens if the trademark gets litigated and where the weaknesses and the strengths are. So you probably are going to get a better quality trademark if you work with a professional. But that's just, it depends on your risk tolerance and your budget. That's not for everyone.
Another example I'd use is, like Rich was saying, as far as clearing your trademark with a search before you file it. It's not as simple as just going onto the website yourself and doing it. As experts, we have a database that we use that enables you to search for not just something that's exactly the same name as you, but something that has minor variations, which might still come up if a trademark office examiner looks at your trademark. And like Richard was saying, you might get an office action from the trademark office where they found a similar trademark on the register if you file it yourself. Whereas if you have an expert do a search beforehand and they spot that, you can either, like Richard was saying, not adopt that name and choose something else in the first place to avoid the complication. Or sometimes there's ways where we think we can slide it through the trademark office, through the technical ways we are filing it, what classes we're filing in, how we describe the trademark, and what exactly we're filing, whether that be the words or the logo, and what combination.
Right.
And I just want to add, coming from the entertainment business, and my husband's a television producer, and there have been situations where he has been involved with people who've come to him with an idea or something, and there have been some legal issues, and he will drop it immediately. He's, I am not dealing with it. And any other kind of studio is not going to deal with it. They just don't want to be involved. So if you want to just avoid that, if you're getting to a place where you have a TV show that's super exciting, I would cover your base, do it properly.
So we also had, this one I thought was interesting. If a speech is published in a newspaper, can I use it in a play?
A speech, like I don't know, I guess some public speaker made a speech and it was published in it really depends on the context.
Yeah.
Yeah.
If it's verbatim and the play is you're selling tickets, I would say no.
Yeah. I wouldn't do it yet.
Unless you get permission from the.
And when was the speech published?
Yeah.
If it was too long ago, the copyright may have expired or had not been renewed under the old Copyright Act. To what extent? Because some people, when they're speaking, they relinquish the copyright and just let people reproduce it. So to what extent did that happen? Again, it's very context dependent. You need to look at the facts.
Yeah, I have a friend who's the GPS girl. And, she actually took a speech that the Australian Prime Minister had given and turned it into a song, word verbatim. But she did get permission from, and I think it depends on, she did. Yeah. But you can do it.
Getting permission is always
getting permission. Idea.
What could that was listed like a good song? What could I mean? What political speech could possibly? Is it a chart topper in Australia?
What about women's rights?
Probably was a good song.
So then we also have images for thumbnails. So yeah, those. I thought when Pinterest came along, there were copyright lawsuits were going to explode because people are pinning other people's content. So what about images for thumbnails? What can you do? What can't you do?
I would say the same thing that we said earlier. If you're going to take just an image you found on Google Images or something, I'd say you run a serious risk of someone like we were talking about, like a Reuters or an iStock who originally owns that image, coming after you with a letter. Even if it's just the thumbnail of a video, they'll still come after you.
You run that through AI and mix it up a little bit. Is there like a percentage of what it needs to look like and or not look like till it becomes something different?
100%, change 100%, you'll be fine.
For sure. There's definitely not like if you change 10% of an image, it's all of a sudden you're in the clear. There's definitely no hard and fast rule like that. It's going to be, again, case by case. I would be concerned about running something through AI, telling them to change it up a little bit and just thinking you'll be fine on a copyright basis. Maybe you'll fool the web scrapers, so you might not get them those tools that they're using to find it. But as far as like an actual copyright infringement case, I wouldn't think that would immunize you.
Yeah. The standard for copyright infringement is substantial similarity. So nobody really knows what that means. And so as a practical matter, what happens is if it ever goes to court, one side puts on their expert that says it's similar. The other side puts out their expert that says it's not similar. And then the court and the jury decide whether it's similar or not. That's what you're dealing with. So, like I said before, copyright law is squishy. There are not always really super clear answers, and there's higher risk and lower risk kinds of things that you can do with that. And again, where experienced attorneys can be helpful is in having seen enough to make slightly better judgments about what could happen. But once you get into court, all bets are off. The jury may not like your tie. They may not like orange ties.
So
many people don't, but you know, so it's just,
so
yeah.
yes. So this is a follow-up question to an earlier one. So this person has a paid membership that means, and she wants to use videos for educational purposes, a YouTube podcast for educational purposes. Is that legitimate or copyright infringement? Is it educational? The members are paying her, so can she do that, or where does that fall?
Yeah, that makes it murkier, definitely, if you're getting paid for it. Again, fair use is a balancing test, and so it depends on the primary purpose. I'd say when you have something that's getting paid for, but you're also educating, you might also, like the deciding factor might be how much of the work you're using to educate. If you reproduce the entire YouTube video, then a court's probably going to look at that and say, what, you didn't have to produce the entire YouTube video to educate on it. If you show a couple of 5-second clips from it, that's a much better case for fair use. It's very context dependent, and the safest thing to do would be create a preview and then show an attorney and ask them what they think. But at the end of the day, they can't guarantee anything. Someone could come after you, whether they're right or wrong.
And also getting permission from the original authors
Right.
Is a good step. If we're asked to issue a copyright opinion, we'll go into the copyright case law. We'll look for fact patterns that resemble yours, and we'll look at 10 different cases and look at the common elements for all of those cases. And then we'll see, okay, how did the courts decide with this fact pattern? And then that way their courts are theoretically supposed to respect precedent, right? Although that's it. And then that can form the basis of an opinion. So we look at what other courts have done and decided, and then we can render an opinion for you about what your chances are. For most of these questions, it's not worth it to spend the money. If you're putting out a major motion picture, then maybe. If you're doing YouTube, it's better just to talk with somebody and get some general ideas and go from there.
So here's the one that I can address a little bit. What about the use of music on a podcast? Because I've done a few I hosted a few podcasts with other people where we've had to look for music. There is copyright free music that you can use. There's also, I don't know how much you want to get into the tech, but there's AI now that will make music for you. Pretty scary. I don't know how good it is and if it'll sound like it's made by AI. But yeah, I would definitely look for copyright where it's free.
There's also low cost music that you can buy, and that would also cover your bases. it seems I've made every mistake in the book, so I'll share another one. My husband actually is a part owner of a music company, and I had been given permission to use the music. And so I had used one small clip on a product that I had done, and I put it up on YouTube. I had used it for just to sell, but then I put it like one small piece up on YouTube. And even though I thought I had gotten the permission, I got flagged and I got told to take it down.
By
So-
YouTube? They didn't know that he gave you permission.
They didn't. And again, it didn't turn into an ugly lawsuit, but that was a situation where I actually thought it was legal, but it was still gray enough. So I would definitely get your music, just get it covered. Make sure it's free, or it's somebody you know that you've gotten their permission, or you can buy low cost music that's decent. I don't know AI either yet. I haven't done that.
I haven't done, I'm not gonna get into what I've done with AI because it's a little scary because it does it pretty well. Not perfect, but
We could do this whole presentation with AI.
I don't think the legal answers would be right though, because I typed in some
Yeah,
things
we
and
get
it
some
could.
hallucinations or something.
Yeah. But then here's one that is funny. You're live streaming and a song or other copyrighted work appears and you don't know. Can you be held liable?
What was the question again?
So you're live streaming and all of a sudden something pops up that's copyrighted in your live stream. You didn't know it was going to happen. Can you be held liable?
Yeah, you could. Yeah. Yeah, there's, I don't know if you wanted to.
No, go ahead.
I mean, at the end of the day, if you leave your live stream up and it's going on in the live stream, you're reproducing the copyrighted work. It could be
Yeah.
infringement. Again, context and everything matters a lot, but a live streaming website like YouTube could easily get a DMCA claim and take down the VOD or the live stream or whatever it is.
Yeah,
So-
I guess, so Stephen raises a good point. It's not only just the single incident. There's really like very little damages when something like that happens. So the copyright owner probably wouldn't file a lawsuit, but it does damage your reputation on social. And that's why you can't control everything in life. And if that happens, then maybe you can ask the music player to turn it off or turn the volume down or whatever it is that you do. I was telling Elizabeth this morning, I think I spend almost all of my time saying no to people. They pay out amounts of money per hour just for me to tell them no. That's all I need to know. And so we're just trying to inform you of the rules. You're living in the real world. I can't tell you to violate copyrights or other intellectual property rights. I can't do that. Would be unethical, but also there's common sense plays a role.
Here's one you don't have to say no to.
Okay.
So my name is Emmanuel and I'm currently running a Beyond the Chart podcast for the Forex traders and the tech entrepreneurs. The question is, what are the best ways to trademark a platform that includes both a podcast and a trading community? And so that's one, but here's a super good one. If I interview someone on my podcast, who owns the right to the content? And can I use it for future monetization? I think that's a big one for podcasters.
Okay, so the first question, how do you trademark something that is does multiple things?
Yeah.
At the end of the day, you can do it all in one trademark application. How trademark applications work is that you apply for a word or a logo being used in connection with a particular set of goods or services. And the government, and actually there's an international system of classification, which categorized basically everything under the sun into one of 45 classes, right? So if you're selling t-shirts, that's class 25. If you're making a podcast, that's class 41. So if you're doing multiple things, you just apply in multiple classes, but the government will take a fee for each class you're applying in. And it's $550 per class if you write in your own class description, or $350 per class if you are copying a trademark manual ID that they give you. And then that's a whole other monster that I won't tackle. But the second was, who owns the content if you interview someone? By default, it could be murky and there could be some kind of joint ownership. You really want a contract. In that case, you really want a contract at the outset that will say, you are coming on my podcast and everything you say is going to wind up as a copyright that my podcast business, whatever your entity is, that owns it outright, and you don't have any copyright rights. that's definitely the safest way to go about it. Because if you don't have a contract, that person might come back to you and say, hey, we jointly created this. We have joint copyright rights, and that could be a valid argument. But yeah.
Yeah, and again, you want to be fair to the people who are participating in the podcast. So you have to decide, do you want exclusive rights? Do you want, may be helpful if they share the content, right? I think the main thing is that I don't want them to try to tell you what to do with the content after the show. So you want your freedom to be able to use the content the way you want to. But Stephen's absolutely right. Just send an email. Doesn't have to be like a big contract or release that everybody signs. Just send an email. So just saying, oh, just so that we're clear on this, we both can use the content for whatever we want as legal. Or our policy is that we, as the podcast owner, retain all the rights to the recordings, whatever arrangement you want to have, because, and it can be just really that simple. It doesn't have to be elaborate.
And at the end of the day, you can contract for any kind of combination of ownership and rights and money under the sun. However the parties decide they want to handle it, you can contract for it, assuming it's legal. But it's 100% best to just figure it out first, so then you don't have an argument about it down the line and the court has to figure it out. You're always better getting something down in writing.
I have a question actually about that. If you get it in writing, right? You now own this interview. Could you later put together maybe a series of interviews that you put together in a product that you then sell? Does that change anything or not? Once you own it and you can do whatever you want with it.
Yeah, more or less. If you own the whole thing outright, then yeah, you can do whatever you want with it.
Do you need to stipulate that? If you're doing a relatively simple email to a podcast person that you're interviewing, does it need to be more complicated saying that we own all rights?
I would just say we own all rights.
Yeah.
And just say that name.
Yeah. At the end of the day, a lawyer is going to say more clear and thorough you can be in a contract, the better. If it's two non-lawyer parties agreeing on things, just getting anything in writing is better than not. And yeah, just saying I'll own all the rights is pretty unambiguous, and that should probably be good enough.
I want to tell a little story. I don't think we've told enough stories here. So when Richard and I have a ghost story podcast.
I have a campfire story.
But when we started Passage to Profit, the radio show we do at iHeart, that the way it started was we knew somebody and she asked us if we wanted to do it as paid programming because Richard was a patent attorney and she wanted me there, I guess, just because I don't know.
Because you have a sparkling personality.
Okay, whatever. So anyway, her idea was to call it Passion to Profit, which people still call it that even though it's Passage to Profit. So to call it Passion to Profit. So being intellectual property firm, we looked it up and Passion to Profit was trademarked. And the trademark was live. Now, if the trademark had been dead, could we have trademarked ours then if it was a dead trademark?
Yeah, in all likelihood, especially if they weren't using it. If a trademark it dies because or lapses because of non-use or non-payment of fees, it's still possible that the company is using it in the commercial world and they would still have rights to it. They would still have their common law rights. And so they could go back and reapply for the trademark. So that's why when you're doing searches and stuff that you're trying to trade stuff and you see it's dead. Well, you need to make sure that it really is dead and that the company's out of business. Oh, I'm sorry, I didn't mean to interrupt you.
No, that's okay. That was just my question. Do you have any? We want stories from the field. We still want to answer questions, but we want stories from the field. Do you have any good trademark or copyright stories?
Oh, sure. We have, this just goes back to using common sense. We have one client who I dearly love. We've been representing them for a long time. And he was just starting his business and he picked a name and he just really loved this name. He was infatuated with it. Sometimes people get infatuated with their brand and their name. They love it and they just don't want to let it go. Well, we did a search and we found out that there was a company overseas that had a very similar name and registered their mark in the US. They were a small company. And we said, we can probably trademark, but this company could come back and zap us someday. And he was so infatuated with the name that he just decided he was going to go ahead with it anyway. 5 years later, this little company overseas was listed on the NASDAQ stock exchange. They had grown so much, and they decided that they were going to go after anybody in the market that had a name, including our client. 4 years and 400,000 later, his business had grown. We were finally able to negotiate a pretty reasonable settlement, but we had fought this battle the trademark office, and then we filed a lawsuit in federal district court here in New Jersey. And if he hadn't loved the name so much, he could have and assumed his company. He had investors that were upset because they learned that the trademark infringement was going to bankrupt the company. And so he's still there. We got through it. We got a good agreement for him. He only had to change his name a little bit, but these things happen, right? And so this is why it's important to try to get it right from the beginning.
Okay, so here's another one. Somebody wants to use Dove, D-O-V-E, where each letter represents a word. Is the soap brand coming after
What was the rest of the question?
So they're worried about the soap brand.
They were talking
Right.
about acronyms or abbreviations copyrighted.
It would be more of a trademark thing. I would say my initial reaction was that I would be scared to do that, especially just because of the size of that company. It depends what you're doing to some extent, right? 2 trademarks for the same name can exist.
They said there's Dove. Someone in the chat said there's Dove ice cream.
Right. So 2
So-
trademarks can exist under the same
3.
name, even exactly the same name, if they're doing drastically different things with their goods and services. It's still going to wind up being a sliding scale. And at the end of the day, I wouldn't be shocked if Dove came after you just because it's Dove, and even if they don't have that strong of a case. If something is even a little bit related to soap, I'd bet money they go after you. I wouldn't bet any money on anything, but
Or Dove Bar the ice cream too.
Dove
or
Bar.
Dove
So
Bar
it
the
depends
ice
what you're
cream.
doing.
Right. And a lot of it depends on how easy a mark they think you are. So it's like Delta Faucets and Delta Airlines. Those are 2 big companies, and they probably would try to work out an agreement rather than spend rather than spend time litigating it. But if you're a smaller company, they know that they have all the resources, and you're not gonna have much to put up a fight with, and so they'll take advantage of that.
So here's another one. Is it trademarking?
Shouldn't be losing. Who might, in their terms of use, be actually taking some rights for themselves to say, to cover their own bases, to say if YouTube is reproducing it, because in theory, YouTube reproducing it on their own website is copyright infringement if you don't give them the right to do that, which you are by uploading it. So to some extent, like YouTube is taking some rights and it's allowing other users on YouTube to use the video, but you should still be able to go and get your copyright registration with the Federal Copyright Office and enforce your rights in that video against people infringing in other scenarios.
What if you don't want AI to?
What if you don't want AI to use your content?
Are we back?
Yeah, we're back.
Yeah.
That's a
You
battle.
might not have much of a choice. There are a bunch of different creative, you probably know this, there are a bunch of different creative rights groups doing AI companies like OpenAI to get them to stop using the content or pay them royalties for using the content to train their AI. As of now, AI is just doing whatever it wants.
So I was just looking at the YouTube terms of service, and it's very clear that other users on YouTube get to use your content any way that they want. And that YouTube wants that because they want people to share content, just like Facebook wants they want people to share posts. You still keep the underlying content copyright, but once it's out there on YouTube, people get to use it however they want to on YouTube. They want to be able to link it and promote it. That's how the channel grows. But if you're outside of YouTube, if you're using it someplace else, then you still have a copyright. So
If someone, for example, linked it to a site, just as an example, then
The question is, if someone links it to their meta site, how does that work?
that's kind of pretty detailed question, but just based on the principles here, my educated guess is could be a copyright violation.
So-
I understand it gets complicated.
But the question is, look at the damages. I can never say violate somebody's copyright, but you have to also be a little practical. As a practical matter, if you're a celebrity, people are paying close attention. If it's just normal people.
Okay, thank you.
Yeah, it's 8 o'clock, so I think we're gonna end. We promised everybody that came in person a tour of the studio upstairs. If you have any more questions, reach out to Richard or Stephen. You can go to gearhartlaw.com and fill out a contact form, or email them, our Gearhart at Gearhart or Stephen at gearhartlaw.com. And we give free half-hour consultations. They'd be happy to help you. Thank you, everybody. This was a great meetup, and I loved your questions. A lot of smart people on here, a lot of great creators.